Okay, should we start? What about? So, good afternoon, everyone. Hope you're keeping safe and that your morale is keeping up in these strange times. Welcome to this Doughty Street Snap webinar on AM Zimbabwe versus the Secretary of State, which concerns what the Supreme Court says was a controversial question of the scope of the application of Article 3 of the ECHR on medical ground removal cases. My name is Krishnendu Mukherjee. I'm a barrister in the immigration team here at Doughty Street, and I'm joined by my colleagues Alasdair Mackenzie and Phil Haywood, who'll be talking about the substantive case and also the procedural aspects of the case. For those of you who are new to Zoom and haven't attended a webinar before, you'll notice that your mics are muted and your videos are switched off. That is a presetting done by the host here, so don't be alarmed. It just stops background noise and interference. The format for today is that both Alasdair and Phil will speak for around 10 minutes, after which and we aim to finish on the dot at 4 p.m. We're looking forward to your questions and comments, and if you do have questions for the panel, please use the Q&A function on your screen at the bottom of your Zoom screen, and make sure that that'll make sure that we see them. And if you can direct them to a particular speaker, that would be very helpful. Also, if you have comments and you want to share that with everyone on the webinar, please use the chat function in Zoom. I will share your questions with a panel for them to answer during the webinar, or you can post them, and I may post them in chat too. And if we don't have time for your question, we'll try and respond to that by email. We're also recording this webinar, and a copy will be available on our website soon after we finish for you and any of your colleagues who are unable to attend to see it. So we have a PPT, a PowerPoint presentation, which hopefully you'll be able to see on your screens. And the first speaker is Alasdair Mackenzie.
Right, hello everybody, I hope you can all hear me. Could we get the first slide up if it's not already, because I can't see it myself. Thank you very much. Fantastic. Okay. I'm sorry, my printer is just printing something. Give me half a second. Okay, so I thought it would be helpful if we just go through briefly what the background is, what the history and context of AM Zimbabwe is, because I think it helps us to understand what was being decided and why the case was decided as it was, what the controversial points were and how the court resolved those. So the first case, which I'm sure you're all familiar with, but it's worth just recalling the details, is D and the Secretary of State, sorry, D and the UK, I'm sorry, in the European Court. D was a case involving deportation following conviction for various drugs offences. And as you will recall, the man himself, Mr. D, was due to go back to St. Kitts in the Caribbean, of course, where there was no treatment at all for his HIV and AIDS, which was at a very advanced stage. Indeed, he was considered to be on his deathbed. And he had no family there as well. And his situation, or his case rather, is summarised by Lord Wilson, who gives the Supreme Court's judgment in AM Zimbabwe as being that he, Mr. D, was about to die, and the essence of the decision, this is still a quotation from Lord Wilson, the essence of the decision was not the absence of treatment on St. Kitts, but the inhumanity of, in effect, pulling a man off his deathbed. Now, it's relevant to note that it's not suggested in AM Zimbabwe that D is wrong, or that it would be decided differently today. It's merely said that it doesn't represent the full extent of the protection of Article 3 in health cases. And that's an important distinction to bear in mind, particularly when we come on to look at the next case, which is, of course, N. And the first of the N cases is, of course, N and the Secretary of State in the House of Lords. N, again, you will recall, was from Uganda. She was also HIV positive and had AIDS-defining illnesses, but she was improving under medical treatment in the UK. And the House of Lords expressly found it rather difficult to see where that fitted in with the D scenario, because she's not on her deathbed, unlike Mr. D. She's recovering, but if she was returned to Uganda, of course, she would deteriorate again, albeit over a time frame which was slightly harder to define than in D. And they found it difficult to understand why it was obviously less cruel to send someone back to die over the course of a year or more than it was to send them back to somewhere where they might die immediately. But the House of Lords regarded themselves effectively as confined by D to interpret Article 3 as being limited to situations where the person's dying, is receiving treatment in the UK, and would be unable, owing to a lack of care and treatment in the country of return, to meet their death with dignity. N then goes to Strasbourg, and we get what some people would, I think, regard as a still more unprincipled decision from the European Court, which doesn't even have the benefit of the expressions of concern offered by the House of Lords, or their sense of frustration at being hemmed in by a decision which, as far as they're concerned, doesn't make an enormous amount of sense. And the Strasbourg Court in N basically says that the future for Ms. N is so uncertain that there can't be a breach of Article 3. Of course, uncertainty you'd think ought to have worked in her favour, but it didn't. The European Court talks about the high threshold set in D. It says that although there may be other exceptional circumstances, that is to say, circumstances above and beyond the deathbed cases, which is what D is found to represent, there might be other exceptional circumstances where Article 3 might be breached in a health case, but it doesn't identify what those might be, except to say that they don't exist in that particular case. And then in a still more peculiar decision in many people's view, they say, oh, by the way, no separate issue arises under Article 8. So both N decisions, I think it's fair to say, are more or less overtly political decisions. They both refer to the heavy burden which would be placed on contracting states if they had to provide free and unlimited treatment to everyone with serious medical conditions which couldn't be treated in their home state, or to become the world's hospital, as it's sometimes put in that rather disparaging phrase. And it's hard to avoid the sense that indeed the European Court was confronted with a case which it thought was genuinely exceptional in the sense of unlikely to be repeated. And then when its implications for other cases became clear, it found itself unable to identify an intellectually coherent basis for it. And of course, it was criticised at the time, the N decision, including in dissenting judgments in N itself. I'm going to skip over a couple of the other cases, which are also looked at in a little bit more detail in the AM Zimbabwe decision itself. And I'm going to come to Paposhvili. Paposhvili, of course, was a citizen of Georgia. He'd lived in Belgium for about 18 years. He had a wife and children there. He'd been refused asylum, but he'd also been convicted of various offences. So he was also facing deportation like D, but not like N. He had leukemia, for which he was being treated in Belgium in the hope that he might get a blood stem cell transplant. But neither the drug treatment nor the transplant were available in Georgia. So, in fact, Mr. Paposhvili, I should say, died during the course of the proceedings before the European Court. But the court was so keen to sort out the problems that had arisen, the legal problems that had arisen since N was decided, that it gave judgment anyway. And the court said it was going to clarify its decision in N, and the Supreme Court is later quite critical of that particular formulation, pointing out that the convention is supposed to be a living instrument, and therefore it should be, and in fact is, perfectly okay to develop the understanding and application of Article 3. And when I say develop, I mean change the understanding and application of Article 3. So this word clarification takes on a certain amount of importance when the case gets into the UK courts, and we'll come back to that in a second. And the key paragraph, which you've got up there, but I'll read out just in case anybody's on audio only, is paragraph 183, where the European Court says that very exceptional cases within the meaning of N, so that's the cases going beyond the deathbed cases like D, should be understood to refer to the removal of a seriously ill person in which substantial grounds have been shown for believing that he or she, although not at imminent risk of dying, would face a real risk on account of the absence of appropriate treatment in the receiving country, or the lack of access to such treatment, of being exposed to a serious, rapid, and irreversible decline in his or her state of health, resulting in intense suffering, or to a significant reduction in life expectancy. Could we move on to the next slide, please? And I'm going to break that down a little bit, but thank you very much, as it's quite a dense paragraph. So first of all, the person has to be seriously ill. Secondly, there have to be substantial grounds for believing that they're at risk, and that obviously means on the basis of evidence. And Phil's going to come on in a moment to look at what the evidential requirements might be. Thirdly, not at imminent risk of dying. So as I said, this is in addition to the D cases, the deathbed cases, which remain intact. The Supreme Court rather later points out that this must mean not at imminent risk of dying in the host country, in the UK, obviously in this case. Otherwise, the whole thing makes no sense. So the point about not at imminent risk of dying means that they're not in the host country at imminent risk of dying. Then there's a real risk. Well, we know what a real risk is. That equates to the Refugee Convention definition of a reasonable degree of likelihood, significantly less than a 50-50 chance, but more than a fanciful possibility. Fifthly, the appropriate treatment in the in the receiving country needs to be either absent or inaccessible. So we move beyond the idea, which is often propounded by the Home Office, that as long as there's theoretical access to treatment, that's okay. And the European Court later goes on to talk about how this means practical accessibility to the individual concerned. And Phil's going to talk about that in a second. Sixthly, the risk has to be on account of the absence or inaccessibility of such treatment. So there has to be a causal link between the lack of treatment and the health consequences. And then there has to be either a decline in health which results in intense suffering and is serious, rapid, and irreversible. So subject to the next point, which I'll come on to in a second, we're not talking about diseases which don't cause intense suffering, if there are any. We're not talking about slow or gradual declines in health. And we're not talking about curable diseases or effects which are reversible. So it's serious, rapid, irreversible, and causing intense suffering. Or, and this is the other alternative, I'm sorry, somebody's saying that there's noise of typing. There's no noise of typing here, so I don't know where that's happening. It's not happening chez moi. So if there's interference on the line or a noise from somebody typing, I'm terribly sorry, but it's not happening here. Significant reduction in life expectancy we've come on to. The intense suffering and the reduction in life expectancy are alternatives. You don't need both. This is the important point. And there's a certain amount of confusion when the case gets into the Court of Appeal as to where the boundaries lie, what the alternatives are. But it's clear from the European Court's decision, Paposhvili, that you don't need both intense suffering and a reduction in life expectancy. And the Supreme Court later points out that although that must mean a substantial reduction in life expectancy, what that means in practice is very fact specific. So a reduction in life expectancy to 1 year, if you're 75 years old, may not be very significant or substantial. But of course, if you're 25 and your life expectancy is reduced to 1 year, then it is very substantial or significant. And the European says this means there's still a high threshold for success, and that's something which the Supreme Court also underlines. So coming on to the domestic proceedings, when the appellant in AM Zimbabwe tries to rely on Paposhvili in the Court of Appeal, he has to concede that his claim fails. And it's worth pointing out that up to that point, he'd only run his case on the basis of Article 8, because his case couldn't succeed at all under Article 3. He then starts to run an Article 3 case once he gets to the Court of Appeal. He accepts that has to fail because of N in the House of Lords. So he's setting himself up, obviously, for an appeal to the Supreme Court. And this Court of Appeal agrees with that, says it has to fail, but it nevertheless expresses its own view on what Paposhvili means. And it gives it a very restrictive view, suggesting that there's only been a, quote, very modest, unquote, extension of N, in part because the European Court has claimed to be only clarifying its previous decision, and because in the Court of Appeal's view, it had upheld N. Now, we don't need to be too concerned with what the Court of Appeal decided, because the Supreme Court didn't accept that approach. It says it's clear that whatever it says on the face of it, the European Court was really doing a lot more than just clarifying N. It was changing the N approach. And it also points out that the European Court doesn't expressly uphold N. On the contrary, the Supreme Court points out that on an application of the Paposhvili criteria to the facts in N, i.e., that it was very likely that the individual would suffer a substantial reduction in her life expectancy, N would have succeeded. So if you apply the test in Paposhvili to the facts in N, you'd have got a different result. So they say that the law has clearly been changed, and it's not just a clarification of whatever the European Court is pretending. So on that view, N has been consigned to history, and most of us will say hooray to that, I suspect. But Lord Wilson also stresses that the test remains a demanding one. Now, Phil will deal with the factual and evidential requirements, but and we will answer questions. But just to anticipate a few questions, let me just say one or two things. First of all, is this the last word from the European Court? Well, probably not. There's a case called Savran, and Denmark, which is a mental health case, which initially succeeds in the fourth chamber, I think, of the European Court on the basis of lack of accessibility of treatment in Turkey, but which is due to be reviewed by the Grand Chamber. So it may be that the European Court will have more to say on this soon. Secondly, are mental health cases covered? Well, answer yes, the previous point. And in any event, it would seem very likely that a risk of suicide would be covered by either a substantial reduction in life expectancy or intense suffering. So you get in under either of those headings. And of course, the fact that a reduction in life expectancy is an alternative to intense suffering would appear to open the door in at least some cases to success, even if there isn't a risk of suicide or death by neglect. What about Article 8? Well, we don't know, but it's worth recalling what's been said in the past, i.e. that Article 8 isn't to be seen as just a more easily accessible version of Article 3, but it covers different rights with a different test, and of course with a balancing exercise. What happens to Mr. AM? Well, he gets his case remitted to the tribunal because, as I say, he hasn't had the opportunity to argue Article 3 properly before, because it was presumed that that line of argument wasn't open to him at all. There's a direction, or an indication at least, in the Supreme Court that it would be helpful for that to be decided by a presidential panel at the earliest available opportunity, which I imagine is very much what will happen. Okay, so that's my bit. Thank you very much. We'll now move on to Phil.
Yeah.
Hi, good afternoon. Can I just check everyone can see and hear me?
I can, Phil, but everybody else is muted.
Oh, right, okay, yes, of course. Thanks very much. Now, thank you very much, Alasdair, for dealing really, in effect, with the substantive content of Article 3, which is one of the two central parts of this, given that it, as Alasdair has indicated, it, at very least, however one puts it, modifies or really substantially overrules and rewrites N. There's a second important part to Paposhvili, as it's being the second part of this is in relation to the procedural protections that Article 3 provide in a health case. Now, if I can just take you to there are two slides, and in the AM judgment, Lord Wilson refers back to the central sections in the Paposhvili judgment, beginning around 180 of Paposhvili. And I think while the Supreme Court is admirably succinct and clear in terms of the applicable framework, it's certainly very important actually to go back and read Paposhvili with care, because I think there are things that you can further flesh out in the light of Lord Wilson's summary. Now, the other thing, just drawing on what Alasdair was saying earlier on, there is another case, this case of Savran and Denmark. It's referred to and cited by Lord Wilson in the Supreme Court judgment. And again, an important case, and one really worth looking at carefully. That case is going to the Grand Chamber. I believe it was referred to the Grand Chamber in January of this year. And I believe also that the UK is seeking to intervene to make representations in the case when it comes before the Supreme Court, before the Grand Chamber of the European Court. Now, to some extent, Lord Wilson, when he made his observations about the procedural protections within Article 3, was conscious of the fact that some of the procedural guidance provided by Paposhvili at least may be subject to some clarification once the Grand Chamber has a chance to actually look at Savran. And if you have a chance to read Savran, in fact, you will see really that it is a controversial case because there was a split in the court 4-3. And one can well see really why the minority was actually very unhappy about the potentially even greater widening of Article 3 in the context of that case. Perhaps I'll come back to that in a moment after I've gone through some of the framework set out in relation to procedural protections as highlighted in AM Zimbabwe by Lord Wilson. Now, perhaps fundamentally, all of this really is directed, in Paposhvili, the court's very clear to explain really that Article 3 fundamentally in these types of cases will very much be directed towards giving an individual an opportunity within an appropriate mechanism to have their case, their claim adjudicated on. In a sense, it's not a role to be taken by an expelling state to, of its own volition, identify cases which may require protection. It's really providing procedural protections, an appropriate court or tribunal that the particular person can go to and argue that there would be a breach of their rights under Article 3, which really brings us to the first part of all of this. Now, as really is conventional with any allegation of a breach of a human right, it will be for an applicant to adduce the evidence which is capable of showing the breach. Now, Lord Wilson, at paragraph 23 of the court's judgment, very succinctly lays out the various elements of procedural protection as they're set out by Paposhvili, by the Grand Chamber in Paposhvili. To start with, there's this rather convoluted test where the court says that it's for the applicant to adduce evidence capable of demonstrating that there are substantial grounds for believing that one of the kinds of scenario arise, as Alasdair has just explained. It's either a complete absence of appropriate treatment, and of course, appropriate here is a fundamental qualifier, very important, or it's about the lack of access to treatment. Lord Wilson thought in practice that it might create some difficulties, but really, because of this apparent double requirement, but in effect, probably what we're talking about is a requirement to show that there are substantial grounds for believing that one of these particular scenarios, as it's laid out, and Alasdair has helpfully, in the second of his slides, laid out the various elements that individual has to actually demonstrate to make good their claim. So really, what this highlights, and I've, in the second paragraph indented in that slide, I've just laid out some of the things that Lord Wilson highlights really as being important. Well, of course, an applicant who is trying to demonstrate to the Home Office or later on to a tribunal that his or her condition would breach Article 3 if removed, will need to produce details and high quality medical evidence. Certainly in AM Zimbabwe, when the case came before the court, one of the difficulties that the Supreme Court had was that the evidence was rather old, but at least part of the evidence came from a nurse practitioner, and there was only a relatively short letter, I believe, from a consultant who had treated AM. So really, there is a need, as in all of these cases really, to have high quality medical evidence setting out the current treatment. In AM Zimbabwe, an issue that arose, given that AM was on a second or third line antiretroviral because he had been unable to tolerate the use of a more generic treatment, was really about the availability of that particular drug treatment in Zimbabwe and whether there would be other alternatives that might actually suit him and without creating the bad side effects, and would be available in Zimbabwe in return. So those are all things that really needs to be carefully dealt with in the evidence if there is an issue of availability of treatment. And then the other connected questions relate to the possibility of actually accessing that treatment. And that throws up, Paposhvili makes this very clear, and Lord Wilson picks up the theme. There are disparate considerations that one has to look at, such as the cost of the treatment, where the treatment is located geographically. If, for example, someone is looking to a support mechanism, a family network, whatever it is, in their village, which really is geographically very remote from a large city where they might access that treatment, not an uncommon scenario, then that's all going to be relevant and part of the factual mix that must be carefully presented. And certainly in Paposhvili, the existence of family and the possibility of community support were extremely important. And really that theme was developed further in the Sovereign case, in which the minority actually were very critical. Now, just to be clear about what this test means in practice, if you look at the last paragraph on the slide, which is a quotation from what Lord Wilson says at paragraph 32 of the judgment, he is quite clear that this is a high threshold test. As he describes it, really, a reference to prima facie breach is perhaps in some senses a slightly misleading term. He makes it clear, really, that what in effect is being said is that the breach must be established absent evidence which will challenge or counter the conclusion that basically is placed in evidence by the Secretary of State. That's obviously very useful in the sense that once you have presented that evidence, unless it's countered, you should be entitled to actually win. Now, can I move on to the next slide, please? Thank you very much. Now, the considerations that Lord Wilson goes on to identify procedurally, he sets out really what the court said between paragraphs 186 and I think 191 of its judgment. So once the evidence has been adduced, that it shows the difficulties with access to treatment, then it will be for the Home Office to actually dispel those doubts. Now, he's quite clear to slightly clarify the language language used by the court in Paposhvili, and to make clear that really we are talking about serious doubts about the factual scenario in return, whether there will be a resulting risk of an Article 3 breach. Looking at all of this, I think it is important to go back to Paposhvili. Its use of language, the court's use of language there, is very helpful potentially to us. There is, for example, reference to a need to show treatment that is, as the court terms it, sufficient and appropriate. Now, that potentially is a formulation that really, when you look at all of the facts, is extremely helpful to us. I mean, sufficient in terms of the availability, for example, of medication or a treatment regime that really will be sufficiently effective in treating a condition. The treatment might not be appropriate if, for example, it's in another area of the country, or simply cannot be accessed because of its cost. And when the evidence is considered with the requisite scrutiny, it will then, as the court and Lord Wilson makes clear in recapitulating, be the responsibility of the Home Office to actually dispel any doubts about the possibility of a breach. Now, in the case of where a case is well prepared, there is good medical evidence about prognosis, about the impact of the effective withdrawal or discontinuation of treatment, and where there is good expert evidence about the accessibility of that treatment and its cost, and where there's good evidence that really looks at the holistic picture about the need for family and other kinds of social support, then it's probably going to be quite difficult in some cases for the Home Office to actually actively dispel the at least the strong prospect of an Article 3 breach that is reached. Now, all of the highlight laid out in this case by Lord Wilson, he acknowledges and he says that he thinks that it's possible to be sufficiently clear about the general procedural framework, that it's probably reasonably settled. But I think it is subject to an important caveat because the sovereign case is going to the Grand Chamber. So in some senses, as Lord Wilson acknowledged, what he was saying about all of this was to some extent contingent on that. And it'd be very interesting actually to see what the Grand Chamber does in relation to health cases. Perhaps I could just return to the second of Alasdair's slides, just to sort of pick up some points about why the guidance that Sabran provides may be actually, well, it's possible to see how the case could be unhelpful to us, particularly with the UK now intervening and perhaps other states trying to do so as well. Sabran was a case, a young Kurdish man who'd been living in Denmark for a fairly extended period of time, and like AM Zimbabwe, had the authorities wanted to deport him on the basis of a not very attractive criminal record. He was diagnosed as having paranoid schizophrenia, and the general indications, he required to be treated with medication which required regular monitoring. The medication was clearly available to him he needed clozapine primarily. It was available to him on the evidence in Turkey. There was evidence that he would receive treatment and that treatment was accessible. Now, what seems to have convinced the court, without actually necessarily having clear and explicit evidence on the need for family support, there was an absence of family for him in Turkey because his family had settled in Denmark. And secondly, a feature of the evidence, and again, it's not an uncommon part of the sort of psychiatric evidence that we might well be presenting to a tribunal, indicated that simply providing him with medication and providing him with the follow-up blood test that he required was really only one part of the regime that he needed to have access to remain well. He needed regular follow-up and a contact person, as I think the court termed it, within the community to make sure that he was remaining well and that he was taking his medication. And it was a lack of access or a lack of clear evidence showing that access that really persuaded the majority, and the court split 4-3, that there was a breach of Article 3 likely on his removal. Now, for the minority, this really pushed the bar too far, and they're very critical of the way the majority chose to actually interpret and apply Paposhvili. And I think, just coming back to the last of the little 7 in Alasdair's helpful breakdown of the relevant questions, when you look at a case and whether there is an issue about a serious, rapid and irreversible deterioration, one can well see, as the minority thought, that in a mental health case, for example, conceivably, depending on the facts, there's a range of speculation which is a strong element of speculation, perhaps, about whether the individual's health will significantly deteriorate. It raises other questions simply about just where you set the bar in terms of the treatments that must be available. And they were also critical in another sense, which, I mean, I don't know, depending on how the Grand Chamber decides to take this, whether they will decide that there is a distinction between physical and mental illness. They thought that, the minority certainly thought that the consequences for mental illness possibly were, there was a higher element of speculation about how an individual's illness might develop. So I think those are some of the questions that the Sovereign case flag up, although certainly the key principles are probably, as Lord Wilson says, reasonably settled, certainly in terms of the procedural approach by Paposhvili as it's been set out in AM Zimbabwe. So I think that's really what I would like to say at the moment, just about the procedural protections in AM. Thank you very much.
So thanks very much, Phil and Alasdair. That's certainly some good news for those of us who've been frustrated by the high thresholds in these medical cases. We've now got around 20 minutes or so for any questions. There's a couple of questions. One that I wanted to ask, which might be useful, is obviously the UK's obligations are engaged on expulsion of someone with medical problems. How important is the fact that the claimant or the applicant should be receiving treatment in the United Kingdom following from AM Zimbabwe and Paposhvili?
Shall I try and answer that?
Sure.
Yeah.
I mean, I think the answer is probably not, actually. I mean, it's going to be an evidential point. I mean, clearly, if the person's not receiving any treatment, that might be likely to be taken by the tribunal as an indication that they're not really ill. I mean, we've seen that kind of thing a lot from the tribunal, of course. But I don't see anything in either case which suggests that you have to have been receiving treatment in this country. The question is whether, because there could be all sorts of reasons why you're not receiving it. One of them being possibly that, you know, the NHS is overloaded. The question is always going to be whether the treatment would be practically accessible, available and practically accessible to you in the country of return. It doesn't seem to me that they're asking the courts to sort of draw a comparison between what people are receiving here and what they're going to receive in their home country. Phil, what do you think about that?
No, but I agree. I mean, I think actually the way, there's a phrase in Paposhvili, I think they say really the fundamental task is to try to determine how your health would evolve. So, I mean, if you're looking at the consequences of return, there may be lots of reasons why actually you fare a lot worse once you are back in the place that you're being sent to. And there may be unstable factors beyond, for example, the requirement to be medicated or whatever it is.
Yeah, and that obviously particularly arises in mental health cases.
Yeah, I mean, you can see a situation in which someone is stable, they're not threatened with removal, they have a stable family situation, whatever it is. Their conditions really are quite good, and then suddenly they're facing return and to very difficult conditions.
Yeah. And I mean, just to pick up on the point about Savran, I mean, it seems to me that the reason for the concern of the minority in Savran is that they say, well, you know, you've got this test in Paposhvili of intense suffering or you know, shortening of life expectancy. Well, Mr. Savran's not going to die, apparently, according to the evidence, so he's not going to have a substantial shortening of his life expectancy. Is he going to be suffering, is he going to experience intense suffering? Well, they say we can't see this from the medical evidence. Actually, the medical evidence, which is quoted by both the majority and the minority, suggests that the big problem for Mr. Savran is he's going to start committing offences again, that he's going to actually be a harm to other people, a danger to other people, not a danger to himself. So it does seem to be a dispute on the facts in Savran rather than about the test. I don't see anything in the judgment itself, or certainly not in the minority judgment, which says, you know, we don't like this test very much, and we think that the Grand Chamber ought to have yet another look at it and perhaps go back on.
No, of course, but I mean,
I wasn't saying that's what you were saying.
No, I mean, I think my point actually, I'm sorry if it came across different. It's very much in line with what you were saying, which is that you know, there's a speculative element as to exactly what was going to happen to him. I mean, was he going to deteriorate on the evidence in a way that really would cause the intense suffering that was required? It wasn't entirely clear to the minority on the facts that it would. I mean, I think some of the older cases, I mean, the case like Ben Said is actually helpful, isn't it, in the sense that it makes the point that a significant deterioration into a distressing condition such as psychotic symptoms is capable of founding a breach of Article 3. Those kinds of older cases are helpful.
Okay, thank you. Marissa's asked a question which may undercut the speculation that the courts may have to engage in, which is the issue of assurances. Obviously, we see assurances in other issues such as the use of the death penalty and fair trial and so on. I mean, how much do you foresee the Home Office obtaining assurances from countries to which they want to return people?
Well, again, shall I start off on that? I mean, in my experience, they very rarely do. Obviously, they're encouraged to do so by Paposhvili. Paposhvili, the sort of fallback argument for the state if they can't show that there is general availability of, or if they lose on the question of general availability of treatment, is to seek specific assurances. I mean, whether the Home Office is actually capable of doing that in other than the most extreme cases, such as SIAC cases, for example, as they do in attempting to get assurances that people aren't going to be tortured in national security cases and SIAC cases and so on. Whether the Home Office is going to be capable of doing that in the sort of run-of-the-mill, as it were, medical case, I rather doubt, actually. I don't think they're that well organised, but if they did, I'm not sure that there's much to say other than that one would need expert evidence as to the reliability of assurances of that sort in that particular country, and expert evidence as to the likelihood that those assurances might in practice be made good. I mean, I think that's going to be a developing area because, as I say, I mean, others may have different experience, but I can't think of a single occasion when I've encountered that kind of thing.
I mean, it's difficult to see how some countries will agree to routinely grant the assurance either, isn't it? I mean, in the manner of these things, I mean, the SIAC type case involves very high-level negotiation about actually the return happening, and not necessarily going to be keen about large numbers of their nationals being returned, so they can be treated there. So it's not obvious necessarily that the Home Office will secure it, even if they actively go after these assurances.
Thank you very much. There's one question on the chat from Millie. Do you have that? does anyone anticipate the Home Office arguing that someone without leave or who is undocumented is not entitled to secondary care in the UK and therefore could be deported without breaching Article 3 because they wouldn't be able to get treatment in the UK anyway?
I mean, I can't see that it shouldn't make any difference. Can you, Alasdair, I think
you're muted. Al, you're muted.
I'm so sorry. No, I agree with what Phil says. I mean, I can see the Home Office arguing it, but the Home Office argue all sorts of nonsense. But is it actually going to be an argument which carries any weight? No, I don't think so. I don't think that that is relevant. The treatment that you're receiving in the UK or are not receiving in the UK is relevant. And of course, the fact that you're not entitled to secondary treatment in the UK if you're undocumented is a problem which the Home Office itself can deal with by granting you leave. So I don't think that would be much of an argument.
I mean, it's an argument that goes back to the early cases, isn't it? In D, I think Mr. D arrived at Gatwick, was immediately arrested because he had cocaine in his baggage, and they were trying to argue that because he'd never actually entered the country and was immediately put in prison, that there's no actual entry to the UK, that sort of bound the UK by any requirement to treat him. I mean, I don't think the argument didn't go very well when they made it.
Okay, Nigel's asked I think a follow-up question on the Q&A. Does not the first requirement of being seriously ill suggest the person is currently seriously ill, as opposed to will be seriously ill in the country that they're being returned to? And if so, if someone is seriously ill in the UK, is very unlikely, even in mental health cases, that they would not be receiving treatment here.
Well, sadly, I don't think that's correct. I mean, I've got a lot of mental health clients who are not receiving any treatment here. But the first part of the question, yes, I think it does imply that you're seriously ill here already.
Phil, do you have anything?
I would agree.
Okay, we don't seem to have any more questions, either in the Q&A or the chat. Do either of you want to say anything else?
Somebody emailed me a question earlier, which was about affordability. This was Stefan Gentili, if he doesn't mind me saying who it was. And he asked about affordability and the question of whether it makes a difference that the treatment is available but not practically affordable to the individual. Again, I think that that shouldn't make a difference. The fact that the treatment is there but is out of your financial reach would mean that there's a breach of Article 3 if you can't access it. I think that's the answer. But again, you know, these are things that are going to have to be teased out in the future case law, and it's not, you know, it's not exactly unpredictable that the courts and the tribunal will find ways of, you know, bringing these questions back into play, even though they seem to have been knocked out of play by the European Court. But on the face of it, it seems to me that affordability should make no difference. If you can't afford the treatment, then it's not available to you.
Yes, I think that's right. At least as things stand at the moment, Paposhvili and what the Supreme Court says.
I mean, asking a sort of topical type of issue. Let's say you had a client who had a pre-existing medical condition such as diabetes or a lung condition, but not serious enough to reach the threshold. Not a very serious condition here, but was being removed to, let's say, India, where they could contract COVID-19, which might cause a premature death because there's no testing and no medical care. Is that something that you would envisage the courts engaging with?
I mean, the Home Office objection to it will always be, won't it, that it's a speculative claim. I mean, the evidence, the medical evidence would have to be sufficiently strong to actually make out the case that there was a sufficiently strong risk. Is there another question? Sorry.
Yes, Ruth Mercer's asked a question. Where a UK doctor has confirmed the needed treatment, do you think the report on availability in the home country needs to come from the doctor in that country, or would a health researcher or other professional from that country, e.g. social worker, be sufficient?
I think it's difficult to give, I think it's difficult to give a clear answer. I mean, I think probably as with evidence generally, I think perhaps you start from the general. I mean, certainly Paposhvili makes very pointed reference to reports by the World Health Organization and other reputable NGOs, as the judgment terms them. So I mean, that's the context really, and then perhaps you look more specifically at expert evidence, which might be pointed towards individual client circumstances.
Yeah, I can't visualize a social worker being able to answer that question, I have to say. As to who would be best placed to answer whether particular treatment is available, I mean, I think that entirely depends on the expert. They don't have to be a doctor. Indeed, you could say that, you know, just being a doctor doesn't necessarily give you an overview of, you know, the availability of treatment for a particular condition in a particular country. I mean, if you're a cardiologist, you're not necessarily going to know what, you know, HIV treatment there is across a particular country. You know, not intrinsically. You might do or you might not do. I think it's a question of identifying the expertise of the particular individual to be able to give that expert evidence on that particular point.
I mean, certainly evidence like social work evidence might be extremely useful. There might be something like this, for example, in a mental health case, or where someone, for example, has a sort of debilitating physical condition, and to be able to answer the question as to what's going to happen to that person when they return to that particular community, is precisely the kind of evidence that may actually be really important.
Okay, thanks. Millie asks, what constitutes seriously ill? Are there certain illnesses which always fall into this category?
I'm not sure there's an easy answer to that. I think it's, again, a question of...
I mean, it's an illness really that fits within the schematic, isn't it, really? Where if there's an absence of adequate treatments, that there will be intense suffering and or a significant reduction in life expectancy on the facts.
Okay. Jackie asks, could someone comment on what they think the approach in this case might be when dealing with illness in family members?
Sorry, I didn't quite catch the question.
Yeah, it's in the Q&A, but it says, could someone comment on what they think the approach in this case might be when dealing with illness in family members? Is that maybe an Article 8 type question? I'm not sure.
I'm sorry, I'm not sure that I entirely understand the question. Is it about carers? Perhaps you could just rephrase the question, Jackie. Sorry.
Yeah. So basically, the question really is about, let's say, where there's a family unit going to be removed and where one of them is really ill. Is that the question? In which case there might be sort of crossover between Article 3 and Article 8, where one family member is so ill that they need to remain in the UK. I don't know if there's a supplementary question on that. Or whether we could just take it as an email, this question afterwards.
Take it as an email.
Yeah.
Kieran O'Rourke says, do you see any differences where the ill person being removed is a child, where the impact on the migrant parents in such circumstances? Do you see any differences where the ill person being removed is a child? What is the impact on the migrant parents in such a...
Yeah, I mean, I think because best interest considerations come into play. I mean, it's certainly in the pre-existing case there was potentially something that was relevant, wasn't it? Either in terms of the greater care that needed to be taken because of the fact that the individual was a child, and also just the possibility of greater suffering arising from a parent sort of witnessing what was happening to that child.
Al, do you want to say something?
Yeah, I agree with that. I mean, there's existing case law which says that the Article 8 threshold may be more readily reached in the case of a child than an adult. Clearly, one can envisage all sorts of situations where a child will suffer more than an adult will from a particular illness. And obviously, when one is looking at questions of life expectancy, again, clearly a shortened life expectancy for a child will be much more substantial in the wording used in Paposhvili than it would be for an adult.
Yes.
Okay, I think one last question, given the time. Charlotte McLean, is there a logical end point to the thrust of this case law, in your opinion? Given that this is all dancing around the fact that some countries have much better healthcare systems, and it seems desperately unfair and cruel to exclude people from access to those, and it's basically policy considerations which are dictating the heavy limitation of application of Article 3 in health cases.
Well, it'd be nice to think that with Paposhvili and this clarification, we're sort of near the end of the road and there's some kind of appropriate balance where, I mean, it may be a relatively hard test to actually make out a claim that you're going to suffer because of the condition that you have and the lack of practical access to treatment that you require, but that those cases will succeed. I mean, it's certainly logical, isn't it? I mean, the old case law, as Alasdair was saying earlier on, there was just no coherent logic to it. You deny people treatment, but you can't really think of a sort of intellectually sustainable reason for doing that.
Yeah, I mean, it's a great question, but it's a huge question.
Yeah.
And, you know, the answers in the end are political answers. You know, why is it that some countries don't have adequate healthcare systems? Why is it that some countries can't treat HIV in the same way that we can? Why is it that we can't treat COVID-19, apparently? You know, I mean, these are enormous questions. I mean, one would hope that the principled answer, it seems to me, is that, you know, if you don't want people coming here to use your health system, you help to develop the health system in other countries. You know, we've certainly got the expertise and the money to do that. But, you know, we're straying beyond the law here into politics, aren't we?
Thanks very much. Yeah, I was going to ask one more question, but I think that's already been answered earlier by both of you, and we could reply back to that. So it's 4 o'clock practically. Thanks very much, everyone, for attending. Dr. Street Immigration team will have further webinars within lockdown, and it just ends for me to say, stay safe, everyone. Thanks very much for attending.